Close enough. We were 3 minutes out. All righty. Good not evening. Good afternoon, everyone. With me is Lynn Marie Garcia. We're going to watch this criminal reform. I don't even know what you call this thing.
It's a committee for criminal justice reform. It's part of our legislature that's in Austin, Texas.
And this is a something significant can happen today.
I wouldn't say that it would happen today, as far as releasing her or anything. This is an interim study, as to what did or did not take place as far as the judicial system and Melissa's case. Mr. Sines has been invited to attend this, by the way.
Yeah, the DA, Louis Sines. Hey, Juanita La Mera Mera, welcome. Thanks for hanging out. Ida. Yes, this is going to be... I mean, I honestly don't know exactly what's going to go on, but I know somebody wants answers on things, right?
Yes, the Judiciary Committee wants to question Mr. Sines about procedures that may or may not have taken place.
And John is up there. I don't know if you guys can see in the front row, far top right. Bald head. That's our John. Next to him is Michelle. And some of the other supporters. Is that Margaret? The second row is the first one here in the second row to the left here. With the gray salt pepper hair?
Yes, it is. Yes, it is.
Okay. And then all the many of the supporters of the family are here wearing their T-shirts in the rows, a couple of rows back.
I'm surprised that the guy with the cap is being allowed to keep the cap on. Because in courts, you're never supposed to wear any kind of headgear, even the women. Now, in the Fifth Circuit, the women can wear hats, but the men cannot.
Could it be because they don't consider this a court session, like a common court session?
I don't know, because I know that we've always had to do proper protocol even in these kind of sessions.
So this is supposed to begin at any moment now. They said 3 o'clock, so.
I see one of the justices has arrived. She's on up at the top. Well, not justices. I hate to say it like that, but one of the legislators.
Again, welcome everyone. Everyone who's there. I'm not going to be popping the comments too much. Don't want to distract from what's going on and what we're going to hear. Tina Weaver says, yeah, it's disrespectful to have your cap on. Yeah, I don't like to wear a cap when I go indoors somewhere. I take it off. Just, I don't know, common courtesy, right?
I think so. I mean, even a good cowboy will take his hat off at a table. Lots of cameras on John right now.
And here's John. If you can see my mouse right up here, John and Michelle. And then we spotted Jennifer. This is Jennifer here, I think.
That's Jennifer there, yeah.
Yeah. Jennifer Toon, she was on the show just a few days ago. And some of the other supporters of the family and the Free Melissa Lucio Project are all here sitting in the back. There's Susan right there. Abe is over here somewhere too. He's further out. We can't see him. I think he's right behind John. So,
I recognize him. He's going to be sitting down. Yeah.
So just keep in mind, everyone, there's not a whole lot to listen to right now. They've got the microphones cut off. We are expected they'll go live. I mean, they're live already, but with audio and begin the process, the event any minute now. We don't have a what do you call that? Like in baseball, you got a program of all the players and all the who everybody is. Landy, bro, it's not like that. She's actually innocent, and eventually charges will be brought up where they see fit, but they're not on her. They are not on her. And you keep hear people saying watch the movie. Well, actually, there's a good reason for it, and it's spelled out very clear cut in that documentary.
I see part of my staff, Teresa Kern Lewis, is online with us. She helped work this case when she first started working with me. This was one of the first cases she worked with me, so she's very familiar with it as well.
Mm.
Another one of our girls, Becky Creel Wilcox, just started watching. Thank you, Becky.
Yeah, this is a criminal justice reform discussion. I guess that's a good way to put it, right?
It's I wouldn't call it a discussion as more as I would an investigation.
Yeah, they're calling it a study, interim study.
Mm-hmm. Trust me, it's going to be an investigation.
Who's up there with John? Any idea who that is?
Yes, she is part of the prison reform group. I can't think of her name, but I do recognize her. She's not with this legislature group, but she's just part of prison reform.
There we go. Everybody's finally coming in and getting comfortable.
There should be 2 more. Unless this is their forum today.
I hope somebody remembers to turn on the audio.
If this is anything like those that I've been before, they'll do the Pledge of Allegiance normally.
Are any of the children against their mom present? Is it one of the questions, one of the comments, and that is a negative. The ones that are against their mom have mostly been barking things up on YouTube, on TikTok.
Thank you, Jeanette. Appreciate it. Rebecca, these interim studies or researches, as what I call them, investigation, they are to determine where there are flaws in the judiciary system so that they can go in and make the necessary changes in law that will prevent this from happening to anyone else.
Hey, do you guys have sound? Can you hear that, Marie? Marie, you can hear the sound?
No, I don't have any sound.
No sound. Okay, hang on. Let me restream this thing and get it going all over again. Gotta ask. Somebody mentioned there's no sound, and he's been talking for a little bit already. So this is the window I got to share.
Yeah, we're going to try to reboot it. For those who can't hear, we can't either.
Can you hear now?
I can't.
We welcome you to, if you could
yes,
here to come in and find a seat, and if not, to fill the room. And then to all of the Texans who are joining us online, I know we've got several legislative colleagues in the House and the Senate who are tuned in live who could not be here. And to all of the people of Texas and even outside the state who are focused on this important hearing today, we welcome you, and we look forward to having a really, really great, vigorous discussion. let me just make some brief remarks at the outset, and then I know Vice Chair Moody wants to make some remarks, and members, if you have anything that you want to add, we welcome that as well. Today's hearing is has been planned on relatively short notice. We did not expect this to be the first hearing of this committee, but the circumstances and the time-sensitive nature of a current death row case, the case of Melissa Lucio, I think demand and command that we be here as policymakers. Make no mistake, this is the people's house. This is not our house. This is not the house of any elected official. This is the people's house. And our job in the Texas House of Representatives is to ensure that we're doing everything possible to make sure that the voice of the people of Texas is heard loud and clear in their house. And that's what we're here for today. We are not here today to relitigate any specific case. We are not here to go on a fact-finding mission. We're not the fact finders. We're not the judge, the jury. We're not the district attorney or the defense counsel. We are legislators. We're policymakers. But we have an important and very unique oversight role when it comes to any issue affecting the liberties and freedoms of all Texans. In this case, one Texan specifically in Melissa Lucio, when those freedoms and liberties are on the line, and when justice itself is on the line, we have not only an opportunity, but an obligation to ask the tough questions, to make sure that the system works. And when we have reason to believe, not a small reason to believe, but many great reasons to believe that the system is not working and that the liberties and freedoms of any Texan, in this case, Miss Lucio, are on the line, then that's why we're here today. So we're going to ask some tough questions today in an effort to uncover the truth, in an effort to figure out how the system is broken and how we can fix it. Representative Moody and I, Vice Chair Moody, and a few other legislators who aren't here today went to Gatesville, Texas last week and visited Miss Lucio on death row. And as we left there, we were almost speechless. But the immense weight, among other things that you feel when you're there on death row, and when we met with Melissa, and as we were leaving, one of the things that just occurred to me was the immense weight of our responsibility and the immense power of government to do good and to do harm, to protect the rights and liberties of the people and possibly to violate the rights and liberties of the people. And we promised Miss Lucio, as we hugged her neck and held her hand and prayed with her, Vice Chair Moody and the other legislators, members, and I promised her that we would do everything we can to push the pause button. At the very least, just to push the pause button, because in 2 weeks on April 27th, the life of a fellow Texan is on the line. There's very real questions, not only about guilt or innocence, but about the process in and of itself. And what Texans, whether you're for the death penalty or not, what you want to know more than anything, what I want to know more than anything as a citizen of this great state, is that the system can be trusted, that it's fair, that it's reliable. And right now I have, as a policymaker, severe and sincere questions and concerns about whether that's true. So that's the goal of today's hearing. I'm hopeful that the other legislators who are tuned in, maybe some of our statewide lawmakers who are tuned in, the Board of Pardons and Paroles, that the decision makers, because we're not the decision makers here, but that the ultimate decision makers will say, you know what, this committee shed light on some real issues, and it's the only right decision right now is for us to push the pause button at the very least, and that's all we're asking. So members, I thank you for being here today. I look forward to a great discussion. And with that, I recognize Vice Chair Moody to bring some remarks.
Thank you, Chairman Leach. I'll quickly echo your comments about the Speaker's dedication to criminal justice reform. This is something that's not new to him, but this construct that we sit here in today is new. And so I'm grateful for that, because these are issues that don't usually look like this. You and I sat in criminal jurisprudence, I don't know how many nights, over and over again, and a lot of times the cameras weren't here, and we didn't see interest in folks that had been warehoused in our prison system. And I think that is starting to change. And I am usually a member that focuses on policy and rules and procedure and try to keep very focused on those things. And I'm going to focus on them today. But I can't start this process without telling you what's on my heart, which is that 1 week ago, I got to hug Melissa Lucio. And this morning I got to hug her son, John. And it's not lost on me that that's something he doesn't get to do. And in fact, if the state goes forward in killing her, and let's not mince words, that's what it is, he will not get to do that again. And so that's what sits in my heart today, and that's why I'm grateful for your leadership and your commitment to her and her family to do everything in your power. So with that, I saw your posting like everybody else in this committee, and one of the terms that hit me the hardest was the phrase prosecutorial discretion. And when we talk about prosecutorial discretion, I think it's important to look at it as both something that can do justice and that can do injustice, that can right wrongs or that can create them. And it's no secret that part of what inspired this hearing is Melissa Lucio's case. And her case is a perfect example. A prosecutor who went on to end his career in federal prison used his discretion for political purposes in a way that put what I believe is an innocent woman on death row, while her co-defendant was given a mere 4-year sentence. We now have an opportunity to see that injustice righted through the use of prosecutorial discretion on the execution date. But this issue is about more than one case. It's about the thousands of decisions that happen every day across Texas. Decisions about who gets charged, what charges are filed, and how those charges are prosecuted. The reality is that a tiny percentage of cases actually go to trial. So the prosecutors making those decisions are effectively the last word on justice for almost every single case in this state. We're here today to make sure we understand that process and can craft laws that promote the best possible practices in discretion so that Texas justice is fair, smart, and effective. Mr. Chairman, thank you for that opportunity.
Thank you, Vice Chair Moody. Members, any other comments? Ms. T, do you have any comments? Okay, we can hear you loud and clear, and you're recognized. If you want to say.
Thank you so much.
Ms. T, did you actually want to, did you have any comments or not? I'm just trying to give you the chance.
No, I just want to make sure that you knew I was present.
Oh, we know you're present, Ms. T.
Thank you.
We
All
know
right,
you're
thank you so
present.
much.
You're staring right at us.
Well, I'm just so sorry I'm not going to be there to see my good friend Mr. Lewis Sines, District Attorney for Cameron County. I was hoping that I was going to be able to be there, but I want to give him my regards.
All right. Well, thank you, and we'll get to Mr. Sines in a few minutes. Absolutely, yes. You're recognized for a comment. You make sure your mic is on.
Very honored to be part of this committee, this interim committee, and very grateful. It's very, very unusual to let a member that, onto this committee that's not an elected official from Texas, and I'm actually from Utah, and so I'm not sure what's going on that you'd allow a Utah on this committee, but I will tell you, I've spent 25 years in the criminal justice system. Most of those I've had the power of the prosecutor and exercise discretion. One of the last cases I did was the prosecution of the kidnapper of Elizabeth Smart. I'm very proud of that. Very proud of the fact that I know that there was justice that was achieved. But I'm also aware, Mr. Chairman, that there were mistakes that I made as a prosecutor and discretion that was exercised. And I even had an instance in which I was, thank God, I was able to understand before it was too late that I had charged an innocent man. And we don't know as a prosecutor that all of our decisions are correct. But I will say that we do know that there really, as Vice Chair Moody indicated, there's really no check on a prosecutor that is currently in the system that is adequate. And so I want this committee and I want the folks in Texas to know how vital and important and how much the country is looking at what you do. When I travel the country and I talk about reforms, and when I helped to work on the First Step Act and the passage of that, and I worked on the predecessor bills with the Obama administration, it was Texas that was leading out, and the whole country watches Texas. And so for me to be sitting here with you all in an opportunity to do something that I think people are getting nervous to do, and that is to hold the criminal justice system accountable. And whether you're conservative or whether you're left-leaning in your politics, it shouldn't matter. We should want to hold government accountable. So I applaud you, and I'm grateful for this opportunity, and hope that I can add in some ways to the great work you're going to do. Thank you, Mr. Chairman.
Members, any other questions before we call our first witness? Just my final remark, just to piggyback off what you, Brett, said, and you, Vice Chair Moody, put so well. I believe so strongly that the system has failed Melissa Lucio at nearly every turn. I've spent weeks, hours upon hours, reviewing this case, as many of my fellow legislative colleagues have. That's why nearly 90 state representatives have signed on to a letter, again, just asking for the pause button. Multiple state senators are working on their own letter now, which I hope to be released later today, maybe tomorrow. The good news is that we have an opportunity now to right the ship and to fix the system, not only for Melissa, but for others who could possibly be in her spot. And so what we're doing today, let's be very clear, does not weaken the criminal justice system. This strengthens the criminal justice system. These hard conversations and these tough questions and rolling up the rug and putting it in the corner and cleaning out dark corners that need to be cleaned out and holding folks responsible, this strengthens our system. And so, members, let's not look at this as something that could potentially weaken the system, because I believe the very opposite. And with that, I'm going to call our first witness today, Mr. Galvan, if you'll make your way up. The chair calls Johnny Galvan and his daughter, Carmen Galvan from Brownsville. It's wonderful to have you both here today. One of the things that is most troubling to me about this case is the fact that as of this morning, 5 of the original jurors who convicted Ms. Lucio of capital murder and sentenced her to death have said that had they known then what they know now, had they been exposed to all this evidence that was out there or that's since been discovered, they wouldn't have voted the way they did. They've publicly affirmed that, and Mr. Galvan is one of those jurors. And so, Mr. Galvan, it's wonderful to have you here today. I understand that Carmen is going to read your statement for you. And members, if you have questions, he'll stand for questions afterwards. So, Carmen, let me recognize you.
Good afternoon, Chairman Leach and Vice Chairman Moody and the rest of the committee. Can you all hear me well?
Why don't you just get the mic as close to your mouth as possible?
Okay. Yes.
Thanks.
So I'm going to go ahead and start to read my father's testimony. In 2008, I served on the jury that sent Melissa Lucio to death row for the alleged murder of her 2-year-old daughter. Even at the time of trial, when it seemed to me that Ms. Lucio's defense lawyers were hardly making a case for her life, I did not want to sentence her to death. I felt pressured by my fellow jurors to vote for a death sentence, but I wish I had never done so. At the trial, prosecutors argued Ms. Lucio had been physically abusive toward her daughter, Mariah, the youngest of her 12 children. The majority of their case, however, rested on Ms. Lucio's statement to the police, the result of 5 hours of interrogation. But it wasn't until after the trial was over that troubling information was brought to light. Now, just days away from her planned execution, I feel deep regret. Since learning about all the things we jurors were never told when When we held Ms. Lucio's life in our hands, I see her as a woman who had a hard life and many struggles, who would have been anyone in my community. I did not know that her long history of physical and sexual abuse made her vulnerable to falsely confess when we subjected to aggressive interrogation tactics on the night of her daughter's death. No one took us through the interrogation to show us how many times she asserted her innocence or how she repeated the same words the interrogators fed to her. No evidence was presented of that, and it would have mattered to me. It would have mattered to have heard from an eyewitness about the child's fall down the stairs. One of Mariah's siblings saw her fall, but was never called to testify. I have also learned since the trial that the district attorney who prosecuted her was corrupt. He is serving a prison sentence now. That only adds to my belief that our decision in Ms. Lucio's case was wrong. When we took our initial vote on the sentence in the jury room, we were evenly divided. When we took the second vote, I was the lone holdout for a life sentence. The other jurors looked at me and I felt peer pressure to change my vote. I remember one saying we would be there all day if I didn't. If I had known all of this information, or even part of it, I would have stood by my vote for life no matter what anyone else on the jury said. Giving someone the death penalty is a huge responsibility. I took the job seriously and it was never difficult for me. The idea that my decision to take another person's life was not based on complete and accurate information in a fair trial is horrifying. There are so many problems in this case that I believe she must not be executed. I am joining 4 of my fellow jurors in calling for a new trial. I am now convinced that the jury got it wrong, and I know that there is too much doubt to execute Ms. Lucio. If I could take back my vote, I would. I will be haunted by Ms. Lucio's execution if it goes forward. I pray Governor Abbott grants clemency to prevent the irreversible tragedy of Ms. Lucio's execution from taking place. I was wrong to sentence Melissa Lucio to death. I pray it is not too late to right the wrong. Thank you for listening.
Thank you, Mr. Gavon. Members, Mr. Gavon, thank you again. And for the record, Mr. Galvan's statement is obviously extremely powerful, and we thank you for your courage and your willingness to come forward, including traveling all this way here. He is joined by 4 other jurors who've released their own statements, signed their own declarations, and I do want to mention their names for the record. So obviously Johnny Galvan, Arminio Cruz, Emma Molina, Constance Poland, Alejandro Saldivar, and the 4-person of the jury, Melissa Quintanilla. I hope I said those correctly. So thank you again to Mr. Galvan. With that, members, the chair calls the District Attorney of Cameron County, Luis Saenz, who's joining us virtually. To those folks in the audience today, we apologize that you're not going to be able to see Mr. Saenz, but you're going to be able to hear him. And Mr. Saenz, I want to thank you on behalf of the committee, on behalf of the entire House and our speaker, and I would say all Texans, Mr. Saenz, for joining us today. I understand that you had important business in the district that prevented you from getting here to the Capitol, but fortunately, as you and I discussed, our House rules, which went into effect last session because of COVID, now allow us the unique opportunity to be joined like this virtually. Members, I think that's a rule we probably need to keep, because without that rule, we wouldn't have been able to have you today, Mr. Saenz. So thank you, and we look forward to our discussion. You're recognized by the chair, Mr. Saenz, if you want to offer some brief remarks, and then I know some of the members on the committee have some questions for you.
Yes, I just want to thank Chairman Leach and Co-Chairman Moody for giving me this opportunity and asking me to present testimony on the topic that we're going to be talking about. I want to thank Mr. Galvan for making the trip. It appears that just to be there. Took some effort on his behalf, and I appreciate him doing that. And stand before you ready to answer any questions that you might have regarding the criminal procedure from initial detention to appeal and prosecutorial discretion. Whatever I can do to help y'all, I'm here to help.
Well, so Mr. Sines, my first question as chairman of the committee, and I'm sure the other members, this is probably high on their list as well, is what's your response to what you just heard from Mr. Galvan?
Well, I can tell you that the state of Texas has no higher priority than to ensure that a death penalty conviction and a death sentence is carried out legally and correctly. To that end, we strictly adhere to the rule of law, which sets out the state and federal appeal procedures. This is what we are in the process of doing as we speak. This case is not over. This has not been finally decided. We have at last count about 15 live pleadings that have yet to be heard, 7 in state court, 4 with the Court of Criminal Appeals, 1 in a federal district court, and then 1 proceeding with the Board of Pardons and Paroles. So this case is not over. The system is being tested, and I expect and I have full faith that the system will show that it does work.
So let's be clear here on, and I know we've got a resource witness, Shannon Edmonds, later. There's a couple other witnesses as well who can shed some light on this, but then members, vice chairs, feel free to step in just for the edification of those folks in the room. And Mr. Sines, if I say anything that you disagree with, then please correct me. But essentially right now in Melissa's case, there are 4 different options for her to be granted either a reprieve or clemency. Of course, the Board of Pardons and Paroles right now, who has the petition for clemency in front of them. I'm not aware of whether they've convened yet or met to discuss it, but of course the Board of Pardons and Paroles will then make a recommendation, as they do on every death penalty case where there's a petition for clemency, to the governor, and the governor at that point can either decide to accept or to reject the recommendation of the board. Then there's the Court of Criminal Appeals, and you mentioned a couple of the motions that are currently in front of the Court of Criminal Appeals, which has a number of mechanisms to pause this as well. But am I correct in that you also, Mr. Sines, have the ability almost single-handedly to request? You requested the execution date be set when it did, or an execution date be set. The court granted that request, but am I correct that you also have the power right now to unilaterally, without the Board of Pardons and Paroles or the governor or the Court of Criminal Appeals, to request the execution date to be clawed back?
I'm not sure that I do. What I have in front of me right now is a conviction that was upheld by the Court of Criminal Appeals. We have and that was on a direct appeal. We have the district court that upheld that conviction. We have a 1107 writ that she was entitled to file, which the Court of Criminal Appeals denied. We have a Fifth Circuit. First of all, the district court denying her federal writ. We have an en banc U.S. District Court upholding that, and we have the Supreme Court twice denying relief. So at this point, I have no indication of anything, any reason on why to withdraw the warrant.
Wait, but you could withdraw the warrant.
I'm not sure that I can.
So procedurally, well, it's been done before, and so procedurally, you could withdraw you could go to the court and ask for the warrant to be withdrawn, and it's my understanding that a court has never declined a request from a district attorney to take such an action. I mean, I would expect, Mr. Sines, again, with all due respect, I would expect that to be a pretty important question that you might want to find the answer to.
Well, and even if I had, what legal reason would I give to withdraw the warrant?
So I can think of many. Let's say that what Mr. Galvin just said and what the other 4 jurors have stated in their declarations and in their affidavits about troubling new evidence that was never presented at trial, some of which has been discovered since then. And again, I want to be very careful not to relitigate the case here. That's not our job. That's your job. But for instance, if taking into account what Mr. Galvan just said, what other jurors have said, is that not reason enough for you to maybe find an answer to that and push the pause button just to be careful?
And like you keep saying that we're not going to relitigate it, but that's what we're doing.
No, we're talking about the
you're
process
asking me to
here.
do to relitigate it, and I'm not going to relitigate. I'm not going to get into the merits of this case because the case is still pending. We will do that in the court of proper jurisdiction, not, with all due respect, in a subcommittee hearing.
Well, this is not a subcommittee. This is a standing committee of the House. And I understand what you're saying. We're not going to relitigate the facts. I'm not going to get into, we're not the judge or the jury here. And I've stated that, and I don't think my questions are implying that that's what we're trying to do here. We're talking about the process. The process is very important. And when we've got 15 days before the execution date that you requested and that is scheduled because of your request, but for your request, she would not currently be scheduled for an execution. Yes or no?
Let me ask you a question. The U.S. Supreme Court denied writ on October 18th of 2021. At that time, everything was clear. There was nothing pending. There was no motions on behalf of the defendant Lucio. I waited November, I waited December, and I waited until January 13th to ask for that writ because nothing had been filed. I had a duty to do that, and that's what I did, and I stand by my duty until I'm told otherwise by some court that may still issue a stay, or some district judge that may still issue a stay. And that is what the way that it works. That's the way it's supposed to work.
Did the defense counsel, Mr. Sines, did any of Ms. Lucio's lawyers request meetings with you during that time from October to January or February?
No, sir. No, sir.
There were no defense counsel from Ms.
They requested meetings afterwards, but not before from October to January.
Do you before you state that on the record as fact, do you want to check with your staff to make sure that that's accurate?
I'm not in receipt of anything from them.
Were there requests for, I think that's an important question. You don't have to answer it now, Mr. Sines. I'm not, and the committee's not trying to unnecessarily put you on the spot. These are just important questions that I think we and certainly Ms. Lucio and the people of Texas want answers to.
Well, and believe me, I appreciate that, but whether they did want to talk to me or not, the way that lawyers talk to each other is by motions. They should have filed something before that time. And when I asked for it, there were no motions filed. I can tell you that.
Did you, that is the way lawyers communicate with one another. But, you know, I'm an attorney and we've got other attorneys on this committee. And I frequently talk to other lawyers on the other side without having to go through a court, without filing a pleading. I don't think we'd get anything done if we didn't talk to the lawyers on the other side. Did you notify Melissa Lucio's counsel before you filed that you were going to do so?
No, sir, I did not.
Okay. I think it's a very, very important, members. We need to get an answer to this. And Shannon, I know you're coming up later. Hopefully you can provide an answer to the committee. If not, this is the whole reason you're here, Mr. Sines, is because I believe that Texas law and criminal procedure does certainly allow you, just like you're allowed to request a warrant for execution, you are allowed to withdraw that request.
And at this point, I'm telling you that even if I have that authority, I will not do that.
Okay. Well, let's find the let's first get an answer to. I want you to get an answer, Mr. Sines, and communicate back with the committee as to whether you do have that power.
I don't mean to interrupt you. I'm sorry for interrupting, but I'm telling you that even if I have that authority, I don't intend to do that because I am not going to usurp the authority. I'm not going to usurp what a jury sat for 6 weeks hearing. I'm not going to usurp the authority of the Court of Criminal Appeals, of the writs that they upheld, of the district court, of the circuit panel, of the Supreme Court. I am not one to all of a sudden unilaterally say, well, I don't care what they did, but I'm going to recall the warrant. I'm not going to do that. That's not the way it's done. The way it's done is through the appellate process. They've got motions pending. They may get one of those motions granted, and the court will stay the execution.
Okay.
And that's the way that it's meant to work.
So just based on what you know right now, Mr. Sines, what you've heard today, obviously what you've read about the case, clearly you understand, as we all do here, that most of those, if not all of those motions were decided one way or another based on procedural grounds. None of them reviewed the new evidence that has come in. Do you view it as your responsibility, the district attorney for Cameron County, to review that new evidence?
Well, how do you
you've got
define evidence?
half of the jury, including the jury person.
These are witnesses, and I don't know if they're witnesses. These are people that were not sworn in. They were not subjected to cross-examination. I haven't seen the reports. They have not tendered them to me. I have not had my own expert look at those reports. They have not passed it a Daubert hearing. This is just information that's out there.
Yeah, so Mr. Sines, I think you just hit the nail on the head. That's what we're asking for, time to do all of that.
And
I'm not asking.
The court will give you that time, and I will welcome that. I have no problem with that. My point is that we're going to do it the way that the due process and the rule of law sets it up.
Mr. Sines, my hope is that what you just said does happen. My hope is that the Court of Criminal Appeals, the Board of Pardons and Parole, my hope is that the right thing is done by somebody. But I want to zero in, because I think it's important for the people of Texas, for Melissa and her counsel, but for your constituents who voted for you to be DA, to understand what you understand your role to be. You do have the power. I'm just going to state it. You have the power right now, single-handedly, tonight, to withdraw this request, to push the pause button on her execution so that exactly what you just said can take place, so that we can have new evidence presented, so that there could be opportunity for cross-examination, so that Melissa Lucio will get what all of us are entitled to and what I know you care so much about, and that is a fair trial.
And that may still happen when a court makes a finding that something went wrong and sends it back to us for trial.
Well, and my hope is that happens too. But Mr. Sines, make no mistake, washing your hands of your ability to make this decision yourself is to me it is very, very shocking and disappointing. And I am again, Mr. Sines. It is not my. We are in different branches of government. The executive, legislative, and judicial have very, very unique functions. You know that. And I'm not trying to cross over, this is not the judicial branch. But you are a political officer of the state, are you not?
Yes, sir.
Okay. And so the legislature sets the framework for our criminal procedure, our criminal law, and we have the ability, when we see that being violated, potentially violated, to step in and to make our voices heard. And that's what we're doing here today. And Mr. Sines, I would just beg you, urge you, on behalf of Melissa and her attorneys, but the legislature in the interest of justice, to say, what harm does it do to push the pause button? What harm could it possibly do a single Texan to push the pause button, when the grave harm and the irreversible harm, the unmistakable harm that would do to not only Melissa, but for our entire system of justice, if her execution is allowed to go forward and we find out later that, wow, she was innocent?
Well, I think that's with all due respect, where you're wrong, because this case is still being litigated. We may still have the decision that you're waiting for, but for me to sit here unilaterally and just pull the plug on it, then what do I say to the other 195 poor souls that are on death row right now, who, by the way, are also innocent?
Hey, to the folks in the room, I'd ask that you not comment or have outbursts. Let's try to not do that. Mr. Sines, I'm troubled. I am troubled, because this, to me, when I think about the system and the system failing, not only Melissa but all of us, this concerns me greatly. That that you are unwilling to accept responsibility for requesting the warrant and to assume responsibility for pulling it back and pushing the pause button. That's gravely concerning. Members' questions. Vice Chair Moody, let me defer to Vice Chair Moody first and then other members. Oh, yeah. Representative Button, Chairman Button.
Mr. Sines and ladies and gentlemen, I am not a lawyer. Okay, I'm a CPA and my expertise is in the business area. But I am having a great reputation that I have compassion and common sense as a legislator. I am sitting here really puzzled. This is not watching the Law and Order or whatever, those TV. This is a life or death of a woman, innocent or not. There's one issue right there. But my understanding is this tragedy happened back to 2007 and 2008, the trial going on. And now with everything going on with 5 jurors decided to share the insights and send us a statement. There's a lot of things they didn't even know about that. And you, sir, you just mentioned the execution day. You said it's April the 27th, but you also say that this case is still pending. There are several procedures you can go through. I cannot even repeat what the procedures you were talking about, but I remember you mentioned several procedures. You have to go through that, and we have a few days left. If after so many years, and suddenly you have to go through this extra so many days, so many procedures to go in, and then I hope I heard it wrong, but I believe I heard it very clearly. You said, sir, you are not going to use your authority, even you have the authority. And that's what you just mentioned. It kind of really confused me and puzzled me and concerned me. That doesn't sound like a ordinary Texan who cares for life, cares for the legal system, and cares for the freedom and liberty. So please tell me that, and I'm just too naive, or just because I'm not a lawyer, so I cannot, go into use all those terms to reject. But it seems like just doesn't have any common sense building. Thank you.
Thank you, Madam Chair. Well said. Vice Chair Moody.
Thank you, Mr. Sines. I appreciate echo Chairman Leach's comments. Thank you for taking the time. As someone who served in the district attorney's office in the 34th Judicial District under Jaime Esparza, I learned a lot. Was lucky to have that training, and I know in our hearing today we talked a lot about prosecutorial discretion. But I also know the tasks before you in a county the size of Cameron are vast, and so respect that you're willing to sit here and talk with us when you certainly didn't have to avail yourself of us. I just have some general questions. So you said that at current you have no reason to withdraw the warrant, even if you had so set aside whether you had the power not to. You said you have no reason to do that. That's what you stated? Is that correct?
I'm standing by the decisions of the Court of Criminal Appeals. I'm standing by the decisions of the U.S. Supreme Court. I'm standing by the decision of the Fifth Circuit District Court.
And isn't it true that all 17 judges of the Fifth Circuit agreed that evidence casting doubt on Melissa's statement was excluded from trial?
Ask me that question again.
Isn't it true that all 17 judges of the Fifth Circuit agreed that evidence casting doubt on Melissa's statement was excluded from her trial?
No, sir. A panel of the Fifth Circuit District Court found that. And then there was a petition for a rehearing, and the court en banc reversed the panel.
Okay. I'd encourage you to look back at those. I've reviewed them extensively.
No, correct me if I'm wrong. I mean, that's the way I understand it.
I believe the finding from the Fifth Circuit is that all 17 judges agreed that evidence casting doubt on Melissa's statement were excluded from trial.
Well, and they affirmed the denial of the writ.
Understood. Let me ask you this. So a petition for clemency was filed in this case. Have you reviewed it?
Yes, sir.
Okay. So and so as part of that petition for clemency, there are statements from experts that have been made in relation to traumatic brain injury, in relation to fracture, in related to trauma that's visited upon victims, and how they respond to interrogation. Have you reviewed all those new expert statements?
I've reviewed the allegations or their findings. I don't know what was asked of them. I don't know what they looked at. I don't know what they didn't look at. I don't know when you say they're experts, I don't know if they're in fact experts or not.
No, and those are good questions. So what steps have you taken to answer those questions that you have?
The steps that I've taken is I'm waiting for the court to tell me that we're going to have to retry this case, and then we'll get into that.
So have you spoken to any of those new forensic experts that are listed in the clemency petition?
No, sir, I have not.
You would agree with me in a death penalty case that special death penalty cases are very unique, right? They present very special challenges from beginning to end, and you'd agree with
Absolutely.
that? Okay.
Absolutely.
We have different processes for death penalty as opposed to any other case within our criminal justice system, correct?
Correct.
Okay. And I think one of the things, I think you would agree with me, is that the reason that these things get challenging is because the facts necessarily in capital murder cases can be very disturbing.
That's probably the reason that prosecutors seek the death penalty, is because of the egregiousness of the facts. Yes, the underlying facts. Yes.
And so, because of that, you'd agree with me. I mean, look, you have a different process. You've got an amplification because of the severity of the facts. You would agree with me that puts an additional amount of stress on everyone involved in the process: prosecutors, investigators, jurors, court system, defense attorneys.
I agree with that.
So would you also agree with me then that because of that any flaw or problem that we have throughout that process would also be exacerbated because we're talking about life and death, right? An error in the process is more serious given the nature of the case.
Absolutely, and I don't disagree with all the scrutiny that this case is getting. I welcome that.
Well, and so wouldn't. Well, that leads me back to my question. I have others, but you mentioned there's 14. You said 14 live motions at the district court and court of criminal appeals.
In various courts, CCA, federal district court, here in the state court, the 138.
And there's essentially 14 days until the state executes Melissa Lucio.
I believe that in the next days or whatever before, I do not believe that this execution is going to go through on April 27th.
So
Wait. I'm sorry. I have to step in. Can you repeat what you just said?
I believe
I honestly
that
I didn't understand what you said.
A state court, I believe the Court of Criminal Appeals is going to issue a stay.
Why do you believe that?
Because there's a lot of pending motions that need to be heard.
That's true. Can I ask a question?
Yeah.
And based on my experience, it's very rare in death cases that the execution is carried out on the first setting.
Well,
I have 2 other cases that we're litigating that are now going on their 22nd and 17th year. I have one in particular where the defendant has been convicted twice, and twice he's been sentenced to death, and still the sentence has not been carried out. So, and that's why I told you from the very beginning, this case is not over. It has not been finally decided. I do not believe that the execution is going to be carried out on that day. I believe the court is going to, issue a stay, and it's going to tell us what issues are going to have to be litigated, and it's going to tell us what we're going to have to do. And one of those may be a new trial.
Let me follow up on that.
Can I follow up on that? I'm sorry. I hope you're right. I pray you're right. But if you're not, if the Court of Criminal Appeals does not issue a stay, will you at that point withdraw your warrant?
When is the execution date?
April 27th. You should know that.
Well, I had 29th to 27th. I wanted to be correct.
It's the 27th.
Okay.
So if the Court of Criminal Appeals does not issue a stay, which I don't think any of us know if they are or not, would you at that point be willing to withdraw your warrant for an execution?
If the court does not issue a stay, and if there are still motions pending before that day, I will do what I have to do, which is recall the warrant because it's not ready. Yes.
So just to be clear, because no execution is going to go forward until all of the pending motions are adjudicated. So there will be no live motions before either the Court of Criminal Appeals, the Texas Supreme Court, even the United States Supreme Court. Okay, that we do not execute folks where there are still pending motions. So there won't be pending motions, but there will be everything we're talking about today, severe and substantial questions about the case. So, Mr. Sines, would you, if it was affirmed that you could unilaterally withdraw the execution warrant, would you?
Again, yes. If the Court of Criminal Appeals or a federal court does not step in because there's a pending motion in front of the federal district court where the defendant had asked for a spiritual advisor to be with her at the moment of the execution, that's still pending. Last time that we had a execution about to go on, that held up the whole procedure. So to answer the question that I'm being asked, if a Court of Criminal Appeals or federal district court or any court of competent jurisdiction that has jurisdiction over this case does not issue a stay by that day and there's still motions pending, then the right thing to do is not to go through with the execution. And at that time, I would ask the warrant to be withdrawn.
Okay.
Now, the problem that we have is that I would have to ask the 138 District Court to withdraw the warrant. The defense has filed a motion to recuse said judge. So said judge would not be able to act on any on my particular request at that time unless that issue has been put to rest by that time, by that day.
Well, the motion to recuse, which I reviewed substantially this morning, is a whole separate problem. The fact that Melissa's attorney is now working for you, and I believe his wife is working for the court. That's a whole separate issue that I don't really want to get into.
I understand, but my point is, since that's been filed, the judge right now could not act on my wish, on my desire, on my request.
Okay, well, I am not one of Melissa's attorneys. I'm not going to speak on behalf of her legal team, but I would be willing to bet that if the execution date was withdrawn, requested by you, withdrawn by the court, that those pending motions could be withdrawn and that could be worked out.
I would hope so.
Okay, well, Vice Chair Moody or Representative Cook.
I have a couple more. Right now, there's an application for a stay pending at the Court of Criminal Appeals. Is that correct?
Yes, sir.
And procedurally, you have the option to oppose or agree to that. Is that correct?
Yes, sir.
So given the issues that are present, given your testimony that you don't anticipate there to be anything but a stay, why not reduce the level of trauma that's being rippled through your community, the family, everybody, and just agree and litigate these issues? You say that they're going to be litigated. That's where we're going to get to eventually. So wouldn't one of the ways that we could just short circuit that is agree to the stay and let's go litigate it, and let's allow that to go forward, because that's where it sounds like things are going anyway. Isn't that an option that's available?
To the extent that we're going to have to continue with this case, I want the guidance from the court as to what issues they say they see as being problematic, what issues need to be looked at.
But in the
And
meantime,
that's what the court will give us in issuing the stay.
well, I think that's probably something that could get worked out. I know in a previous case involving Rodney Reed, there was a stay and then a direction sent back to retry on certain evidence. But a baseline of that in this matter could be an agreement between counsel on what should be relitigated or not, or the fact that we can stay it, and then the court can give guidance about what should or shouldn't have light of day in court. I'll leave that to the experts and y'all involved, but procedurally, is that something you can or can't do? You can agree to the stay, correct?
I would prefer the court tell us what the issues are that need to be focused on.
And what bothers me about that answer is I remember sitting in the DA's office and taking cases to grand juries and talking to some of my colleagues, and they go, yeah, I know this isn't, I know I can't do much to this case, but I'll just have the grand jury flush it because I don't want to have to deal with, I don't want to have to deal with the repercussions of someone saying that I flushed this myself. I don't want the responsibility laying on me. But you would agree with me that we have an obligation as prosecutors to do justice. And if we see something in front of us that you think it needs to be litigated, which is what I think I'm hearing from you, and maybe I'm hearing it wrong, that there are issues that you anticipate need to be litigated, isn't it incumbent upon us to get ahead of that and let's go do it? Because what if the court gets it wrong? If the court gets it wrong, then the case is over and her life is over and there's nothing left to talk about.
It reminds me of the case of another innocent man who was in front of the governor, and the governor didn't want to make a decision. The crowd wanted him to die. The governor had sincere questions about his innocence, and he just washed his hands of it and sent him to somewhere else. And they tossed the prisoner back and forth because no one wanted to make the decision.
The distinction that I want to draw with the analogy you put out there is that there is no agreement on what I don't agree with what they're saying is new evidence. And again, without relitigating the case, I disagree with what they're saying happened or didn't happen.
That's fine. That's for a jury to decide.
And that's why I said, let's let it go to the Court of Criminal Appeals. Let them decide. Let them say this is what the problem is, and then we can look at that. And then I'll be glad to have whatever the Court of Criminal Appeals says we need to do.
I beg you, and members, Brett, I think you got questions. David, okay. Before I recognize Representative Cook, I just urge you, Mr. Sines, and I want to tell you how much we appreciate you being in front of us and being frank with us, as painful as it might be. But I just urge you to not wash your hands of this and to make a decision
and I'm not
that
going to
will harm
accept
no
that
one.
characterization. I am not washing my hands of this. I am dealing with it, and they're hard decisions to make, and you disagree with me, but that doesn't mean I'm washing my hands of it.
Okay, Representative Cook.
Thank you, Mr. Chairman. I just have a couple of questions. Just a few minutes ago, when speaking with Chairman Leach, you stated that you might disagree with some of the statements that are being made. Are you referring to the juror statements, or who are you referring to when you say you disagree with who?
So there are theories of what happened or didn't happen.
Okay, but where did you get those theories?
From what they're putting out there, that Mariah fell down the stairs and the issue with the confession.
Okay. And so earlier in the testimony, and I want to remind you some of the comments that Chairman Leach made early on in today's hearing is obviously this hearing today largely deals with the life of Ms. Lucio, but also deals with criminal justice reform in general. And so as a district attorney of the state of Texas, I just wanted to ask you, do you think it's important that you know all the evidence or what you said, theories that are out there? I mean, in making your decision whether or not to withdraw this warrant or to agree to a motion for new trial or anything like that, do you agree that it's important for a district attorney to have information?
Yes, I agree.
And earlier, I think I heard, and I wrote it down, that you said you have not been provided the statements from the jurors. Is that correct?
No, I said I have not been provided the reports from experts.
Okay, well, I'll ask it a different way. Have you received and reviewed, personally read yourself, the statements that have been made by the 5 jurors?
Yes, sir.
And do you agree that that's information that has come out since a court ruling has been made?
Ask me that question again.
Do you agree that those statements have been prepared and disseminated post any ruling from any court?
Correct.
Because I think I heard you say earlier that the last time there was a court hearing or a court ruling was in September of 2021. Is that correct?
No, I said that's when the Supreme Court denied cert in October 18th.
Right, but what I'm saying is that's the last ruling that we have from any court. Is that correct?
No, sir, that's not correct.
Okay, what other rulings have come out?
We have a ruling just last week from the Fifth Circuit in New Orleans denying Melissa Lucio's request to recall the mandate.
Yep, that's fair. I guess what I was focusing on is from September until the time that you decided to issue the warrant, there were no court rulings. Is that correct?
There was no. What I said that was defendant Lucio did not file anything.
Okay, I understand that. I heard you say that, but were there any rulings between September and the time that you issued the warrant?
Between October and the time that I issued the warrant, not that I know, sir. No.
All right. So that's why, I mean, I would implore you to give some credence to the fact that 5 of the 12 members of the jury have made statements since the time. And I know you just said one ruling came out last week, but prior to that time, it had been since last fall, since there was a hearing or since a ruling had been made. And so I would just implore you to give credibility and give deference to the statements that have been made from almost a majority of this jury panel that found Ms. Lucio guilty. I would just ask that you go back and review those statements. Will you agree to do that?
Of course I would, but also, to the extent that there's 5, one has to wonder about the other 7.
Well, you and I both know, I'm not a criminal lawyer, but you and I both know that 7 people could not sentence.
No, and so neither could 5. But if you're wondering about the other 7, I can tell you that out of those 6 that we contacted, 6 of them stand by their verdict, and 1 has since passed away.
Just for public knowledge, how many people does it take to sentence someone to death? How many members of a jury?
It has to be unanimous.
So the answer is 12 out of 12, correct?
Yes, sir.
6 out of 12 is not enough, correct, sir?
That's not my point. You were saying that 5 have said they changed their mind. I'm saying, well, you've got 5 that change their mind. I've got 6 that stand by their verdict.
But can we agree that you should not make your decision on the fact that 6 out of 12, half of the jury, you indicate that that's reason enough to continue with this execution?
I understand that. I'm just pointing out that because you're saying 5 changed their mind. I said, well, 6 didn't. No, that's the only point I'm trying to make. I understand the number.
I just hope that as a district attorney of Cameron County, you don't think 6 out of 12 is enough.
No, sir, I don't think so. Not any more than you think that 5 is enough to reverse it.
All right. Earlier, you stated that you didn't want to usurp or take the step of making a decision yourself to either recall the warrant or to grant, not grant, but to agree to a motion for a new trial or something like that, some positive motion for the defendant. And you stated that you didn't want to usurp the power of all these other courts, and you've named all the courts: the Court of Criminal Appeals, Supreme Court, U.S. Fifth Circuit, things like that. And so what I want to know is there some scenario? I mean, if someone else walked in and and stated that they committed this crime? I mean, is there some evidence, some bar, some level of evidence that would be sufficient for you to quote unquote usurp the power that has been given since the ruling in last fall?
I mean, I'm not going to sit here and speculate on hypotheticals. I mean, I've got what I've got, and I mean, I can't answer that question. It's a hypothetical and without context.
And as far as the statement you made earlier, and I do want to say thank you for your willingness to recall the warrant if the Court of Criminal Appeals does not grant a stay prior to the 27th. I do sincerely appreciate your willingness to do so. But can you give us a timeline of when that decision will be made by yourself? Are you talking like the same day, the day before, 48 hours?
Oh no, I mean I'm a realist, pragmatic. I mean I don't want to be left. I don't want to run the risk that it's not going to be made timely. So I will make it in such a way that it is timely made, so that it doesn't, create a situation where it wasn't timely made.
And along those same lines, could you go ahead and reach out to your presiding judge? You brought up the issue of a motion to recuse earlier. And so what that means is the current judge could not, any order that the current judge signed would be void upon it being signed, correct? Is that what you were referring to earlier?
I was referring that we don't have a judge in the 138 right now for this matter.
And so that we don't run a risk, like you just talked about, you don't want to run a risk. Could you speak with your presiding judge about that?
No, sir, I couldn't. That would be ex parte.
If I'm sure that Ms. Lucio, being a defendant on death row, is represented by counsel, and I would think that her counsel would join you in making sure that there's a judge available.
Unless you represent her, I couldn't, take your word for it.
All right. Well, maybe they're listening to this testimony and that they will reach out to you. But if they do, I mean, you acknowledge that it's important that there be a judge available to sign. And
that's why I pointed it out to Chairman Lee to say I don't have a judge.
Well, as you alluded to earlier, this committee doesn't have any power, any authority over that matter. So it's not going to do any good to tell Chairman Leach. I'm wanting a commitment.
No, I'm sorry, I didn't mean to interrupt you. I was just pointing it out. So look, the issue I have is that even if I file the warrant right now, there's nobody to sign that request. That's the point I was trying to make.
And I appreciate the point, but I'm just asking, will you make sure that your office and counsel for the defendant take the necessary action to have a judge sitting on the bench to sign sufficient order?
You've got my commitment to that. Absolutely, of course.
Thank you, sir, and I appreciate your time.
Representative.
Yes, sir.
Representative Buckley.
Thank you, Mr. Chairman. Mr. Sines, thank you for being here. I'm not an attorney, but I'm just going to try to put my Texan hat on here and just ask you a couple, really a question. You said you've been involved in, a certain number of death penalty cases, and there are 195 cases pending. Have you been involved in a death penalty case where 5 out of the 12 jurors are now reconsidering the decisions they made based upon the lack of presentation of pertinent evidence and new information that's come to light? Is that sort of the exception to the rule?
Yes and no. It's not uncommon for jurors to change their mind once they've thought about it, and it's just human nature. It's what they call buyer's remorse. I mean, jurors change their mind. That's not uncommon. It's not the first time this happens.
Well, I'm not stating that, but would you say, in your experience, though, that this is sort of a case that exemplifies is an example of a large, I mean, I'm pretty well-read, keep up kind of person, but I don't really see this, these types of circumstances very often at all. And when you have a group of, nearly a majority of the jury that says this needs a second look. And with that being said, and with the ability that you have to basically tap the brakes, to push the pause button, I just, as a non-attorney, just as a citizen of this state, I just cannot understand why we wouldn't tap the brakes to allow this process and not run this thing to the edge. Mm-hmm. Why do we want to run it to the edge?
Well, do you know who approached this these jurors, do you know what was asked of them? Do you know who prepared these statements for them? If I come to you and I say, look, you voted to convict this person. What if I were to tell you this? Would that change your mind? You're probably going to say yes. I would say yes. I don't know who approached them. I don't know what they were asked. I don't know if they wrote their statements or didn't write their statements.
I think that's a perfect case for setting the pause button then. Let's ask them.
Yep, exactly.
Representative Bowers.
Of course, he had nothing to say.
Didn't want to talk to me. They got lawyers.
Representative Bowers.
Thank you, Chairman Leach, and thank you, Mr. Sines, for your time. I just have to agree with my colleagues, and I want to ask you these few questions. You yourself said today that the case is still pending early on in this hearing, correct?
Yes, ma'am.
And you said there are a lot of pending motions, right?
Yes, ma'am.
So I think the other thing that came out is that you have not, I think one of my colleagues shared, and you shared as well, that you have not heard expert testimony. There's new information, and it just seems to me that there are a lot of unanswered questions. We've already talked about today that you could make this decision. Do you believe in hearing all evidence?
Yes, I do.
So if all the evidence has not been heard, then why would we go through with some finality? It's an unsettled case, correct?
It has not been finally decided.
So then it says to me then, and I'm not here to do your job. Again, I said, thank you for what you do and for being here, but then it should not be settled. It is not time for it to go anywhere, correct?
And it's not going anywhere.
So you're saying it's not going anywhere. How do you know that? If you have not made the decision, you do not have a judge, are you saying that it is not going to move forward? You already know that.
I believe that this execution is not going to be carried out on April 27th.
So then there's no reason to put the family and everyone else, Melissa Lucio for sure, under undue stress that she could lose her life on April 27th. There's no reason. If you believe that already, what reason?
I believe that because I think that a court is going to step in and stop it.
So you believe or you think?
I believe that the court's going to step in and issue a stay. And that's the way that the system works. And that's why we're here today, to see if that's not the way it should work, to fix it so y'all can fix that.
Yeah, that's exactly why we're here, to see if we can fix things, right? But you have the power, right, to make the decision. You know that there's a lot of unanswered questions already. You know that there's new information. You know that 5 out of 12 has already been made clear, have reconsidered. So what else do you need to make the decision to issue the stay and to put?
At this point, it's not my decision. It's the court's decision to make.
Then
That's the way
at
the
your
rule of law
discretion.
applies. That's the way that it's governed, and that's the way that it works.
It's the court's
I
decision.
think you've been
at
asked for a
his
timeline.
behest.
How long will that take
How long will what take?
for the court to make a decision?
I expect the courts to rule probably this week or next week.
Thank you. Thank you, Chairman.
Thank you. Thank you, Representative. Mr. Tolman.
Thank you, Mr. Chairman. Mr. Sines, thanks for, you've acquitted yourself, in a manner that's consistent with, prosecutors. I sat in your shoes, ran an office, was a prosecutor on many serious cases and had many juries. Is it fair to say that your position is, in essence, that you want the legal motions to go through, you're not taking a position, and you're not going to exert at this point any influence, and see what happens? It's a see what happens with the motions approach.
What I'm saying is that we're not reinventing the wheel here, gentlemen and ladies. There's a rule of law that applies.
Was my statement accurate or inaccurate?
It's accurate. There's
Okay.
appellate procedures
Okay.
that I'm saying let them work.
Let me ask you this. Do you believe that you are prevented from authorizing an independent review of an actual innocence claim in your office?
No, I'm not prevented from that, and we're doing that.
Does this, you're doing it. Have you authorized an independent review of an actual innocence claim in this case?
We're
No.
looking at that.
When you say we're, who
No,
is
he
the
has
staff?
not.
My office, my staff, my office. We're looking at what the other
He
side is
has
saying. We
not
look at that, we
issued an
scrutinize it,
independent
and we
evaluation.
test it and
An
see how
independent
far,
evaluation
how credible
is
that
someone
is.
outside of his staff.
So you've authorized an independent investigation. Will you be making the results of that independent investigation available to the community so that they have confidence that you did fulfill your role to achieve justice and not just win a case?
I'm not here to win cases. I'm here to do justice, and yes, I will do that.
The you made a point earlier of indicating that you're concerned about the other 189 or 190 death penalty cases. I want to drill down on what Mr. Buckley said that I think was important. How many death penalty cases do you have in which you have more than one juror that has come forward and indicated that they got it wrong? How many death penalty cases? Not other cases, death penalty cases.
I understand. Out of the 3 that I'm litigating right now, this is the only one.
Does it concern you? I've been in your shoes. I know there are times I was concerned about getting something wrong. Does it concern you? There are 5 of them. You seem to suggest that somebody might have written the testimony, but you were here and heard Mr. Galvan's testimony, and clearly that was heartfelt and not something that just some advocate wrote.
I don't want to be disrespectful to Mr. Galvan. I don't know him, but certainly some of the language in that statement that was read contains some legalese that I'm not sure a layperson would know to say or to use.
No, that's not true. That's not true.
So in your judgment, the language that he used suggested that it was
I
written
can
by
tell
somebody
everybody
else.
who is listening or watching
Some of the
this
phrases in there, some of the
that
language
no one
are legal phrases and legal
would
language.
even go to him and
So if
have
you've authorized an
affidavit
independent
already made
investigation,
for him to
you
sign.
believe that the date won't hold
These
on the
jurists
27th for
came
execution.
forward
You believe that all motions should be held.
and
Do
have
you
written
think
their own
it
statements.
is satisfactory to have an independent investigation of an actual innocence claim done in a period of a few weeks when there's still information coming out from individuals, including, you and I would agree, Brady and Giglio information that seems to be
And Miller.
raising that have not been raised previously and is not part of the record. So I'm wondering, is that enough time for you to do a satisfactory independent investigation by your office into an actual innocence claim where 5 jurors now say they got it wrong?
Well, I mean, we're not just starting this discussion today because I'm here with y'all. This discussion has been ongoing since I took over the case.
Understood.
Looking at that.
Mr. Sines, I know your job is not easy. I know you indicated that this is the law and that you're trying to follow the law. I would just remind you of Justice Sutherland's statement in Berger versus United States. That's Supreme Court precedent.
Yes.
That says that the role of the prosecutor, he is the representative not of an ordinary party to controversy, but of a sovereignty whose obligation to govern impartially is as compelling as it is to govern at all. As such, he is in a peculiar and very definite sense the servant of the law, the twofold aim which is that guilt shall not escape or innocence suffer. He may prosecute with earnestness and vigor, indeed he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. So I ask you, what harm does it do if you have an independent investigation already going to push the pause button to show this community that you take seriously, that you will use every legitimate means? I don't buy that you have to wait for the Supreme Court or the Circuit Court. You have an immense power granted to you to take a pause and investigate and give to the community a sense that you don't care so much, like you indicated, about just a win, but you care about justice. And that I would ask, and I would implore you to consider and appreciate your time, Mr. Sines.
Well, and I understand, but if I can respond, you premise your whole thought on the fact that I'm going to agree with you on your conclusions. I do not agree with the conclusions that you have reached. I do not agree with the conclusions that the so-called experts have reached.
Well, no, I haven't actually given you my conclusions. I'm talking about process.
Yep.
I'm talking about you doing something that the community then looks to and says, okay, that Mr. Sines, you know what? He stopped, he listened, he considered evidence, he identified through his independent investigation of an actual innocence claim what he thought was credible and not. That does more to suggest that the government listens to its people rather than the people having to suffer what the government dictates.
And I think the people that know me down here and the people that know that the kind of work I do for them every day in providing for a safe community, they know what I stand for and they know me and they know what I'm about.
Then I don't think they would be surprised with you pausing and investigating and giving the community a sense that you do it regardless of whether there's guilt or innocence.
And if I were to come to the conclusions that y'all have come to, I would do that, but I have not come to those conclusions. I disagree with what's being put out there.
Mr.
And
Sines,
is that wrong for me to disagree?
Mr. Sines, I'm here at the Capitol right now. The committee's staring at several of your constituents right now who lost their little sister, their daughter, their granddaughter, and who are facing the prospect in 15 days of having their mom killed by the state. And they're your constituents, and they're begging you just to push the pause button.
Look,
what do you say to them? Has a single member of the victim's family requested you or urged you to set this for execution?
Do you know that baby Mariah was taken from her mother when she was days old? And baby Mariah was returned to her mother almost 2.5 years later. And from day one that she was returned to the defendant's custody, care, and control, 88 days later, she was dead.
Mr. Sines, we're not gonna litigate the facts of this case.
Oh, now you're not gonna relitigate it. Now
Mr.
that you
Sines,
don't like what I'm saying,
Sines,
we're not gonna relitigate it.
Can
That's
you
a
answer
double
my
standard.
question? Can you answer my question? Has a single member of the victim's family requested that you take the course of action that you're taking?
I spoke to a Mr. John, who was very respectful, and yes, I have. And yes, he did approach me.
And I believe John is sitting right in front of me right now, and John wants you to push pause. I'm asking Mr. Sines if a single member of the
Do you realize
family,
what you do to the rule of law when you take a relative with an emotional plea and based solely on that emotional plea, you push the button? What does that do to the rule of law?
Mr. Sines, I would rather you push the pause button than allow a state official to push the button that starts the drugs going into Melissa Lucio's veins.
Well, that's what happens when a jury issues a verdict. That's what happens when a court of criminal appeals opposes the jury's verdict, affirms the case. That's what happens when a Fifth Circuit appeal district court panel opposes the conviction. That's what happens when a Supreme Court twice rejects relief. That's the law that you all created and gave me.
I think we know the answer to your question, that not a single member of the victim's family, not a single one, has requested you to take the course of action you're taking, and they're pleading with you not only on Melissa's behalf, but on Mariah's behalf. Let's not lose sight of the victim of this tragedy on Mariah's behalf to push the pause button.
And
you
that's
have
the
the
first
power.
time you mentioned the name Mariah after about 2 hours.
and you have the power to do so tonight. Vice Chairman.
Wow. Wow.
Mr. Sines, you said you've established an independent review internally. Is that you have a conviction integrity unit in your office?
No, sir, we do not.
So what is the construct that
Well, and there is, I mean, you're using fancy words. We're looking at the case and we look at everything that we're supposed to look at. We're very aware of Brady and board material, and to make that available at the instant we discover, we have not discovered any. So we're looking at everything that's been put out there by your so-called experts, by the theory that she fell down the stairs, by the theory that the confession was coerced, by the theory that or the statement that her experts were not allowed to testify when in fact they were. So we're looking at all of that, and we weighed it out, and I disagree with your findings.
The question I asked was if you had established a conviction integrity unit, and then you decided to pounce on me like those are words that are too fancy.
No, I don't have an integrity unit.
Okay, so then I'm here to talk about process. So what do you have in place? It is a senior trial attorney, an investigator, an appellate attorney in your office. Who is part of the team? I'm just talking about process. Who is part of the team that is looking at the case? That's the question I want answered. I won't use fancy words.
And that's a fair question. I've got my first assistant, and I've got my appellate lawyer, and I've got some senior felony prosecutors that we have a team comprised of.
Okay.
His first assistant is Gilman.
Because again, you're coming to us 2 weeks prior to execution date. You've said this is something that has been looked at for some time. When was that assignment tasked to that group of individuals?
When we started receiving the bevy of first motions, probably back in the middle of January.
Okay, and so when was the petition for clemency filed?
I don't have it in front of me. Probably mid-March, I'm not sure.
Okay. And as a part of that petition for clemency, I think those are some of and you called them so-called experts. It's not my decision to make. Expert designation is something for a court to do. But there are statements attached to the petition for clemency that cover some of that information. Is that information that you have reviewed or that team is reviewing?
We're reviewing it, myself and the team's reviewing that.
Because you said that you've come to a different conclusion than that there is new evidence. And so is their investigation over?
I disagree with the findings that they make, is what I said.
So you've reviewed all of their reports that they've attached to the clemency?
I reviewed everything. Yes, sir.
Okay.
Is Mr. Gilman a part of your review process?
No, sir.
Okay, good.
Okay.
Right.
And the chair will show that Representative Morales is present virtually as well. Go ahead.
Do you think that juries ever get it wrong?
Yes, sir.
And do you think that it's more or less likely that a jury gets it wrong when there's an inadequate defense or a defense of poor quality?
There's various reasons for getting it wrong.
Well, there's one of the ones I'd like to drill down. Do you think it is more or less likely for a jury to get it wrong when you have inadequate defense or poor defense?
Our system is an adversary system, and it works best when both sides are very competent and very zealous and do their best job that they're supposed to do.
True. I agree with that. But you would also agree with me statutorily, the prosecutor as well as being a zealous advocate is seeking an abstract concept of justice. So when there is inadequate defense or poor defense and errors are made, do you not feel like it is a prosecutor's moral duty to right those wrongs if they do happen?
Again, it's an adversary system. I'm not, I'm supposed to do the best that I can. The defense is supposed to do the best that they can. And only by both sides going at it in a very zealous and, dignified way will we get justice.
So just because I can get a plea out of someone that's a weak defense attorney, I should go for it because that's me zealously advocating?
No, sir.
No, right. If you see a defense attorney that's rolling over and isn't doing well by their client, you push the pause button. That's not right. You know that. You don't just roll someone over just because they're going to sell their client out.
No, sir. And in this case, there's yet to be a finding that the defense attorney was incompetent or ineffective.
Well, like I said, I'll let I want to talk broad principles about the philosophy of a case and our system, because I do think it's a duty and it is a unique duty that sits on prosecutors. And it's why we look at them so closely, is because they have that duty to the system as a whole. They have to sit in the room with victims. I've sat in those rooms, victims of some horrific crimes, and they have to look across and make sure that the defendant's rights are respected as well, right? They have all of those responsibilities. So it's not like a civil case and where you've got, they don't have to look out for this side. They can try to, keep this evidence or keep that up. We don't have that luxury in the criminal justice system, and we shouldn't, right? Because the government's trying to deprive you of life and liberty. And so philosophically, you would agree with me that if there are errors, and if we believe mistakes were made, it is the duty and the moral responsibility of a prosecutor to right those wrongs.
And it's the duty of the court to call out those errors. That's why you have appeals. That's why you have points of error. And that's what the courts rule on. They call the errors, not me.
So I have to wait for a court to rule, even if I see something in front of me that's wrong in court?
No, I'm referring to the case that we're talking about.
Well,
I see something wrong in court, then you raise it right there and then.
And so that's my point, is because what I've
this was not raised during court. This is an appeal now.
Yeah.
That's
So
that's what the court's rule on. They
yeah.
call the errors, not me.
Sorry, I have a technical difficulty. You said earlier that you would have no objection to withdrawing the request for setting a date if the Court of Criminal Appeals did not issue a stay. I want to characterize your words correctly. Is that what you stated earlier?
Yes, sir.
Okay, so, and that's based on the fact that you think a stay will be issued in sometime in the next 15 days.
I firmly believe that based on my experience and based on litigating these cases. Yes, sir.
On what grounds do you think they'll issue that?
They've raised so many grounds that I wouldn't know which one to pick. I mean, and I'm not here to pick for them, but I suspect that they're going to find something. Right now, they've asked us to respond to the motion that they have on the recusal, and we had to file that yesterday. That's why I was hard pressed to be with y'all today. And today I had to file the response to our board partisan parole. That's why I was hard pressed to be here with y'all.
Oh, actually, that's something I wanted to bring up. That due date was today for you. The district attorney's office has the opportunity to opine on the petition for clemency, correct?
Yes, sir.
Procedurally, you have the option to do that. You can do three things, is my understanding, and just correct me if I'm wrong. You can support clemency, you can oppose clemency, or you can choose not to submit any opinion one way or the other. Is that accurate, or am I missing?
I've only done that this one time, so I'm not sure that you're accurate or I'm not accurate.
Okay.
I don't want to speculate on that.
So today was the deadline for your office to do that?
Correct. Yes, sir.
Okay. And could you share with me, what did you submit?
No, sir, I couldn't share with that. For the cover sheet on that says something about this is not open to public record and whatnot.
Okay. I'll reach out to the board and we'll visit with them privately.
Certainly.
In prosecuting, there seems to be some urgency in this case, and I don't know why. What is it more important to create a final situation, some finality to this case, than it is to thoroughly investigate and make sure there's no error? Like, is that more important? Because the tone of the testimony seems to be that it is more important to move forward than it is to try and ascertain anything and everything that may call into question guilt in this case.
I disagree with your characterization. It's been 14 years. It's important to keep this thing going, to keep it moving.
Why?
Through the appeals and through the different courts and get to some finality.
Why is it important to keep it moving?
Because justice delayed is justice denied.
Okay. We've had instances in this case, and I've sat with mostly Black men who have been convicted of crimes that they were later exonerated of. One who sat on death row and they pushed to rush his execution, later exonerated for it. Do you think, when looking at those situations we've seen in Texas, do you really think that we can say justice delayed is justice denied? I mean, don't you think that it's more important to get it right than to get to a final irreversible conclusion?
It's important to get it right. It's important to keep it going. And it's important to follow the rule of law.
Okay. And within your powers, and that's why I do think it's important to state this, it is not you usurping anyone's authority. You are a constitutional official in the state of Texas, and you have certain authority. You do have the authority to withdraw that. And so that's not you usurping, it is you utilizing the authority you have. And so I think that's an important distinction to make. And I think another important distinction to make is that you talked about the Supreme Court not giving granting cert to this case, and that somehow we should take that as them endorsing the conviction. But you and I both know that the Supreme Court will grant cert on cases of broad legal principles, not fact-sensitive cases. And that's really the determination that's being made there. There's no endorsement, there's no review of the facts of the case when the Supreme Court makes that decision. Isn't that correct?
That's correct. And my only point in raising that is that I've got, if you were to sit where I'm sitting right now, I have probably about 6 or 7 rulings, all in favor of the state of Texas. All in favor of the state of Texas. So why would I recall the warrant? What basis do I have when all the rulings have been in favor of the state of Texas?
Well,
I'm not sure what your
I would disagree with your characterization, because I think the Fifth Circuit decisions are not uniform across the board, and we have a petition for clemency sitting out currently that has multiple new new avenues to investigate. So those are more than enough reason to hit the pause on a system that otherwise could execute someone who may not be guilty.
And if those are, then the rule of law provides for that, and they will hit the pause.
And I believe, and I'm trying to be very respectful here, but I believe you're abdicating your authority. You are waiting.
No, I'm not washing my hands. If that's what you want to say, I'm not washing my hands.
I said
I'm standing by the verdicts of the courts that I have. I'm standing by the rulings. I'm standing by the trial jury verdict.
Okay. And juries have gotten it wrong many times. I've sat with people that have spent decades in prison, one that died in prison for a crime he didn't commit. So, you cannot push your responsibility to other people. At a certain point, the buck stops there. You have authority, and by you choosing not to use it, you are abdicating it. And that's your decision, and that's fine, and I respect it, but I want you to own it then.
And I own it, and I'm telling you that if I don't get a if defendant Lucia does not get a stay by a certain day before March 27, then I will do what I have to do and stop it.
Okay.
I'm owning it.
Well, I feel very, very confident that we need to members schedule another meeting of this committee to hold you accountable to that. Because what I don't want to happen is for the Court of Criminal Appeals or the Board of Pardons and Paroles to wait until the last minute. And I would just urge you, Mr. Sines, to remember that Melissa Lucio right now has 30 days before any inmate's scheduled execution. They are isolated from everybody. She is no longer on death row. She is in her own unit alone, 23 and a half hours a day in solitary confinement. Cannot go outside at all. She is separated and isolated. And all it would take is for you to push the pause button now. I trust what you're saying is true, that if the Court of Criminal Appeals or the Board of Pardons and Paroles does not take the action that we all think that they should, that you will step in, and we're going to find a way to hold you accountable to that. I trust what you're saying. I have no other choice right now in this moment than to trust what you're saying. And I'm looking at Mariah's and Melissa's family right now, and just reiterating to you that we're going to do everything we can to get this right. Ms. Thompson, do you have any, or Mr. Representative Morales, do y'all have any questions or comments?
Well, the only thing I would say, if Mr. Sines has made that statement that what he would do, I've known him for many years, and I've always considered him a very honorable person, and I would stand by his word. If he said he would do it, I believe he will.
It means a lot coming from you, Dean Thompson. Thank you. Representative Morales, do you have anything? Okay. Members, are there any other questions for Mr. Sines? No. Okay, Mr. Sines, we thank you for your time today. Sincerely, on behalf of the committee and the entire Texas House, we appreciate you being transparent and open and honest. This was the frank discussion that I think we needed to have in the interest of justice. So we just encourage you to, like we are, dig deep on this and to have the courage whenever you feel is the right time to do the right thing for Mariah. Members, any other questions? All right. Thank you, Mr. Sines.
Thank you. Y'all have a good afternoon. God bless y'all.
You too. God bless you.
Man, that was awesome. That was really good.
The chair calls Shannon Edmonds, Texas District and County Attorneys Association. And then after that, we'll end with Allen Place. Hey, Shannon.
Thank you, Mr. Chairman and members. My name is Shannon Edmonds with the Texas District and County Attorneys Association. Here is a resource witness on the question of prosecutorial discretion in the application of the death penalty.
So, Shannon, thank you for being here. I imagine this will be the first of many times you're in front of this committee, and we're going to rely heavily on your input and look forward to those discussions. So first, it's just a threshold question. Did the committee say anything specifically relating to the powers of Mr. Sines and his role right now as the prosecutor for Cameron County? Is there anything that we said that is inaccurate? Does he have the power right now to withdraw the warrant? Can you just discuss that issue for the committee?
Sure. And if I may, I think maybe y'all were talking by each other a little bit. Sometimes policymakers and lawyers, it doesn't always match up. So a warrant is a court order. The court issues the warrant. The prosecutor requests it. So a prosecutor can request that a court do something. It's the judges, the district court judges' decision whether or not to grant or deny that. As I think Mr. Sines said, it's common practice if a prosecutor asks that a warrant be withdrawn for X reason, that a court is going to honor that. There is a statute in the Code of Criminal Procedure, Article 43.141, which lays out the procedures for issuing death warrants. It has timelines. It requires the court to wait until other litigation appeals and writs have been concluded or have reached a certain stage. So it governs all that. The only mention of that statute about withdrawing or modifying death warrants has to do with when the defense files a writ, which is a challenge to the conviction or the sentence separate from the direct appeal, or when the defendant files a motion under our post-conviction DNA testing provision. The statute is silent about what a judge should do when a prosecutor asks that a warrant be issued. But that's probably never been an issue before because no defendant is going to object to a prosecutor asking that a death warrant be withdrawn. And then the statute goes on to say if it is withdrawn and a new one is issued, the date has to be more than 90 days out, et cetera, et cetera.
Can in the situation, Shannon, where Mr. Sines, let's just use this for example, where Mr. Sines were to ask the court to withdraw the death warrant, let's say for whatever reason the court would, sounds like maybe for the first time you know of, that if they denied that request, is that an appealable motion?
I don't know. I've never heard of one being denied. The state only has the right of appeal that you give the state. Prosecutors are limited, and that's in Article 44.01 of the Code of Criminal Procedure. There's a list of things that the state can appeal, but if you don't put it in there, then the state cannot appeal it.
Okay. You have questions? Vice Chair Moody.
I thought I ran out of questions for you. We had a brief discussion about a fancy program called a Conviction Integrity Unit. Can you, I know it's a new construct. Well, I shouldn't, probably not. I think we've probably done it in different ways. I think that terminology is relatively new in our system. Are there elected DAs in the state of Texas that operate, a Conviction Integrity Unit or have, publicly stood up a Conviction Integrity Unit?
Yes.
Okay. Where are those? If you happen to know, or if not, you can provide us with that. Which counties have done that?
I know that the largest counties have Harris County, Dallas County, Tarrant County. I'm not sure beyond that.
Okay. Dallas County, Harris County, Tarrant County. 2 Democrats, Republican. Okay. So you've got people doing this on both sides. Do we provide, as a state, any funding?
Zero.
Okay. I'm going to put a pin in that.
Yep.
If we expect better results from our prosecutors and for them to look at these things and they are willing to do it, we should probably provide them the resources.
If you don't fund it, you can't say it's a priority.
So
each office has different guidelines on implementation of the integrity unit, or have they been using best practices?
So there's no mandate that they have it. So each office builds that and operates it as they think best. I know that those 3 different units all also consult together. And I would submit it's not new. They've been around for at least 15 years, and you might even argue that they were pioneered here in Texas. But they are only possible where the resources are available to do it.
I think that's a very important point. And that's why I fleshed that out with the district attorney in Cameron County. Obviously, I don't think that's something that they necessarily, I don't know the size of their office, but probably not, probably a mid-size office at best. I don't know how many prosecutors they've got, but if we want things like that, if we want those results, best practices to lay out, understand what that looks like with your all's input. But then we also have to put some skin in the game too if we think it's important. So when you say you think that we pioneered that, can you flesh that out for us a little bit?
Well, I think in Dallas County, then District Attorney Craig Watkins, when he took office, was one of the first prosecutors to make that something that he campaigned on and implemented. I don't want to say that was.
Wait,
There's been a lot of turnover in that office. I think it was about 4 office holders ago.
It was 08, I think. Yeah, that sounds right. On the clemency petitions, I characterize options as supporting, opposing, or just not lodging an opinion. Is that, do I have that correct?
I haven't looked at their rules, but that generally sounds correct
Okay.
to me.
And maybe I'll ask this question of Alan, but is that not, those submissions aren't public record?
I've not researched that.
No, that's okay. It surprised me that like a public official could send something to a public board and it not be public record, but that wouldn't be the first time that we've probably done that. But
Yeah.
it's just I'm just curious, because if that's the case, that's the case, but I just was curious to the answer. I don't have any other questions. Shannon, I appreciate you being here with us, and you know, always being willing to dive in deep on the procedure around any of these more complicated issues or issues that we choose to complicate. So thank you.
Thank you, Vice Chair. Members, any other questions for Shannon?
May I take you up on your offer to clarify one other thing?
Please
The
do,
thing was
yes.
confusing.
That's why you're here.
At the risk of violating my rule never to volunteer stuff in a committee. There was a lot of debate about why a prosecutor might not make the decision to stop a proceeding in order to investigate something himself. And I think, again, it was a situation where maybe people were talking by each other. The issue when a prosecutor investigates anything that a defense lawyer brings to him is if he goes, investigates it, and then decides, nope, that didn't pan out. That time is lost in the court process, and nothing prevents the defense from then raising it again in court and it all having to be litigated, only it's done 6 months, a year, 18 months later. So I think what Mr. Science was trying, I don't want to speak for him, but what I heard him saying with my prosecutor ears was, we need the courts to make these decisions so that they are final and those issues can be put aside, and then other issues can be litigated. And to me, that is, and if this is your first opportunity to delve into death penalty litigation, I mean, the procedural standing of this, the flurry of motions at the end, this is standard. Okay, this is how the system works or doesn't work. And part of it has to do with resources and why claims aren't raised until the very end, until weeks before an execution date is set. But it's also common for, it's rare for initial execution settings to be carried out, because when you have that much volume of issues at the end, it's not that the courts are substantively deciding all of these issues. They just realize, well, we can't do this. We can't give it the attention it deserves. So we're going to stay the execution, put it off, and work through all of these issues. And it is probably more frequent than not in a death penalty case that you have a flurry of motions at the end, whether that is a tactical decision or one limited by the defense's resources or something else. This is normal, the procedural standing of this case right now.
But the fact is there are multiple, I don't have the exact number, but multiple inmates on death row, some of whom have been there for decades. I know that there's a gentleman who's been there since the late 70s. And so my question would be, I mean, I see Jeff Wood's sister here in the audience today. Jeff's been on death row since for over 25 years. And his case is just dormant. I don't know the procedural status of the gentleman from the 70s that's been there, but I know there's several. I mean, we saw them with our own eyes last week, inmates who because have we not given the local prosecutors local control to make these decisions, to request an execution date?
Yes.
Okay. So what is what does justice mean for the victims of those crimes that were committed in some cases 40 to 50 years ago? And what is the legislature's role? What is the process? What should be in place to make sure that someone like Melissa, where there are serious questions about her guilt or innocence, there's serious questions about what even happened, and yet she's only been on death row for 13 years, and Mr. Sines has no reason, no request from the victim's family, none. I don't know of a single constituent that's been begging him, knocking down the doors to his office, requesting for their Shannon to be an execution date set. So how do we, what is our role as state policymakers to step in and provide a framework so that someone who's clearly guilty for a crime, there's no question, a heinous crime committed in the 80s, gets to live the rest of their life on death row because a local prosecutor doesn't request an execution date. And Melissa, where there are serious and substantive questions about what actually happened, is 15 days away from being executed. That process to me it's the Wild West.
I've heard our criminal justice system called worse.
Well, I could think of worse, but you know,
But you know, I don't know of any other jurisdiction that has capital punishment that necessarily does it different or better. I know many that have more procedural requirements in them, and most of those end up in a system that never follows through on the punishment. And that is a choice that those states have made to have it in name only. Our state has decided if we're going to have it, we're going to carry it out. And indeed, if there's 190 something people on death row now, I can tell you 20 years ago, there was 400, 500, 600. So the position of the state, I think, has always been ultimately to leave that up to the local officials who know the most about the case.
Yeah, Representative Cook.
Shannon, I know it's a very small sampling, but one of the questions that was asked of the district attorney was about the sampling of, I think, I remember it was Brett that asked the question, but he answered that this was the only case of 3 death penalty cases where he had jurors that were had buyer's remorse, I believe was the term that he used. I mean, from a policy standpoint, again, for this committee's purpose, which is certainly given deference as it should be with regard to the Lucio case, but from a policy standpoint going forward, I mean, is there some number that to where you should have some type of automatic? I mean, just from your personal opinion, you have an opinion as to if 2 or 4 or 6 or majority change their mind. I mean, that just seems significant to me, especially when you have someone that knows it takes a unanimous decision to sit there and justify his decision by saying, well, half of them said it was okay. It really infuriates me that that's justification for a district attorney in the state of Texas to give the death penalty or to carry out a death sentence with 6 of the 12. I think it's a good idea.
Sure. In the context of prosecutor's discretion to decide what to do with that kind of information, it can vary on a case-by-case basis. I have experience with a lot of death row cases from back in the day when it was a much more frequently sought and exercised sentence. And I would say in the clemency review process, it was almost more likely than not that the defense would find a juror who would be willing to say that they would change their mind if they were asked today, based on what the defendant's advocates have told them. So that's something that a prosecutor has to weigh when presented with that kind of information. It is certainly relevant to, well, first of all, there's 2 issues: guilt, innocence, and the sentence, right? And there can be plenty of people say, yes, I mean, the letter I heard today didn't say anything about innocence. It just talked about the death sentence.
I agree.
And so that's something that a prosecutor would need to factor into. It's also someone who has been on the executive clemency side in a prior job. It's something that is relevant to that decision, probably more so than the courts, because it's not a legal basis for reopening a case. And I would submit that if the legislature made it a legal basis for creating a new way to encourage more litigation, you unfortunately are creating an open season on every juror who has sat on a death penalty case, because the defense, who zealously represents their clients, will be duty bound to try to find whatever you set the threshold at, 3 jurors, 5 jurors, to hound those jurors in an effort to try to clear that threshold and get their client another bite at the apple.
Thank you.
Yeah. Good points. Yeah. Anything? Representative Morales or Representative Thompson, y'all have anything?
No, sir, Mr. Chairman.
Thank you. All right. Members, if there's no further questions, Shannon, thank you for your.
Thank you.
He asked.
Oh, you got, all right. All right, the final witness is going to be Alan Place with the Texas Criminal Defense Lawyers Association. Alan, good to see you. You're recognized.
Thank you, Mr. Chairman. Members, my name is Alan Place. I actually live in Gatesville. Next time y'all come to town, y'all should holler
Okay.
before you leave. TCDLA is a collection of about 3,500 attorneys in Texas, men
You
and
can
women.
speak up just a little bit.
Men and women that are public defenders, private practice and firms. My background is in private practice, primarily criminal defense, both retained and appointed cases, everything from Class C misdemeanors to capital murder. It's been a while since I've had a capital murder, but I have had 2 of those in my career. And I've represented TCDLA in this building for 23 years. I know you have a very broad charge. I know it's more focused today. Let me just make some very basic comments, very broad comments, very brief, and then I can maybe address some of the clemency issues that Representative Moody brought up. Basically, we believe, and I know that y'all have been on, those of you who have served on committees that I've testified in front of before, believe that TCDLA believes the primary goal of criminal procedure is not to favor one side or the other. We don't believe procedures should be changed because of the desire to strengthen one side or the other, or because of one unusual, unique type fact situation. We would suggest, to the extent possible, politics or sound bites have no place in determining courtroom procedure. And on a death case, the key is, as Chairman Button said, is to get it right. One of my favorite authors said the one place where a person ought to get a square deal is in a courtroom. And I think everybody on this panel today would agree with that. It is not easy. I understand the realities of this building. But certainly as you go down the road of trying to find procedure, the idea is to, again, I appreciate the comments of the rule of law, but ultimately it's to get it right. And the finality of a death case cannot be overstated. So with that, I would be probably more astute on the area of clemency and dealing with the parole board. That is where my practice has primarily been, other than in this building for the last 30 some odd years. But I would say, and generally on any case that the parole board has in front of it, the vote to approve for parole is a 2/3 vote of whatever the body is comprised of. It's a 2/3 vote. But in a clemency petition, it is the recommendation to the governor is by a majority vote. And since 2007, we've had 7 members on the parole board. The current parole board is comprised of 7 board members that are stationed throughout Texas. And at each office, there are 2 commissioners. On a matter of clemency, on certain types of sex offenses, certain types of crimes, only board members can vote. On other cases, for example, theft cases, DWI type cases, any combination of commissioners and board members can vote. But on these kinds of matters, they are strictly board members. And the difference is board members are appointed by the governor for a term. Commissioners are hired by the presiding chair of the Board of Pardons and Paroles. They are all very serious jobs. I've told them more than once. I think it's the most difficult job in government, candidly. But anyway, that's the circumstance regarding clemency, and it's my understanding, subject to Chair Gutierrez telling you something different, Mr. Moody, when a matter of when a document, or if I appear with someone in front of the Board of Pardons and Paroles, it is my understanding that presentation and any documents I give are indeed confidential and not subject to the Open Records Act. It's a clear exception to our government in terms of how we would normally function. But the rule is there, is my understanding, to give free rein on victims in order to be able to give their side without fear of retribution. And so it does work both ways. Yeah. In other words, if you were there to protest somebody in your public or your private capacity, you can do so with confidence. Okay. And same way, if you were there to appear for someone, you certainly have the ability, and what they take in is deemed, in fact, to be confidential. That's my
so just to understand the process, the governor cannot grant a clemency without the recommendation of the Board of Pardons and Paroles.
That's
correct?
My understanding. Okay. Except the governor has a 30-day
30-day stay.
That's correct.
Okay, and the governor can grant that stay with or without the Board of Pardons and Paroles.
That's my understanding.
Could grant that 30-day stay before the Board of Pardons and Paroles even makes a determination one way or another.
That's correct? My understanding.
Okay. And the Board of Pardons and Paroles does accept and review public comments, correct?
They do.
On any given open case before it.
That's my understanding. On any case, on any matter, that's my understanding.
Yeah. And so at the conclusion of this hearing, I'm going to read off the email address of the Board of Pardons and Paroles and encourage folks, if you have a thought that you want to offer the Board of Pardons and Paroles as they consider Ms. Lucio's clemency petition, I'll just go ahead and give it now. It's BPP for Board of Pardons and Paroles, BPP_PIO at tdcj.texas.gov. Again, that's BPP_PIO at tdcj.texas.gov. I know there's been tremendous public feedback and input so far from members of this committee, members of the legislature, to the Pope, to domestic violence organizations, groups from all across the world who are sending comments to the Board of Pardons and Paroles. And I would encourage folks who are in this room and who may be listening in, especially Texans, to reach out to them as well. Vice Chair Moody.
I think that's a good point. And being not subject to the Public Information Act, I think I could see the policy reason to shield some of that from, okay, I want to make that request, and the government can say, no, we don't have to release that. It is an exception too. But as you know, you can also, that can also be waived. It doesn't have to be asserted. In fact, I think I'll have to go look, unless it is confidential and the person that provides it isn't allowed to set it publicly. I think if someone had sent something in that's subject to a public information request, but it is precluded from being released by the government, the individual can release it if they want to. Like, that's their choice. We get requests in our offices, or maybe it's just mine. I don't know.
No, I get them too.
And I mean, we disclose all the time, even though there's an exception, because I think it's good, when you're a public official, to do that. So I really do. I'm going to look into this. I want to give DA Sines the benefit of the doubt. I think he could have told us exactly what he sent in. Now, I may not be able to get that same information out of the Board of Pardons and Paroles because of the rule you stated. I think I can get it out of the person that submitted. I think it's their right to waive all that, right?
I agree. The person that, what I will tell you on any given case for standard parole, the trial officials under the statute are deemed to be the judge of the sentencing court, the district attorney of the county, and the sheriff. And every time somebody's up for parole in this state, those individuals are given a opportunity to more or less check a box, approve, disapprove, or neutral. Okay, and they can certainly submit more, but I know of nothing that would keep a trial official or anybody else commenting to the Board of Pardons and Paroles of their position. There's no requirement they keep it secret. It's just if they submit it to the board, I don't think you're going to get it back from the board.
So I'm going to put this out there into the ether because I think it's important because of the testimony we heard today. And I do believe there is an abdication of authority, and someone that said, well, if the court doesn't act, then I'll take care of it. Well, I want to know the opinion they lodged with the Board of Pardons and Paroles today, because they did it today. And if they objected to clemency, I mean, that colors the rest of the testimony we heard today. That's disingenuous then to send that in at the same time saying you expect it to get stayed. I mean, that's dancing all over the issue. So I want that answer. And if it is not confidential and it can be released, I think the district attorney sign should release that. Did he agree with the clemency petition? Did he disagree with it? Did he not lodge an opinion? I think that is a basic fact that his community should know. Absolutely. I think it's a basic fact that all of us should know. And I'm disappointed if it is, again, let me caveat that, unless it is confidential and he's not permitted to release it. If he has the exception, he has the power to release it. I think he should. And I wish I could have called on him earlier to do it. I think he should do it.
I also want to be clear that these trial officials are not under an obligation to intervene. And I would say, just an opinion and experience is probably on the majority of cases that go in front of pardons and paroles, the trial officials may not weigh in. It's been my experience. There's always, as lawyers, there's always going to be one or two exceptions, but by and large, unless it's a very heinous situation, a very front page kind of situation, I don't know that necessarily they're going to be weighing in on what I would just term the average, 2-year sentence for theft or something. I don't know that they're going to do that. They have that authority, but they do not have to respond. They're given the opportunity, but it's their call to decide what they're going to do.
Yeah.
Thank you.
Yeah. Representative Button.
Thank you, Mr. Chairman. Thank you, Mr. Place, coming to help us out. As I mentioned earlier, I'm not a lawyer, so I'm not, especially this criminal offense.
You've had the best quote of the day, so there you go.
Well, so let me just try to understand some basic. Yeah. Earlier you mentioned that once there's clemency is recommended, the governor has 1 month to make the decision. Is that right?
I'm not sure the timing of it. My understanding is for clemency, there has to be a recommendation of the majority of the Board of Pardons and Paroles,
Yes.
and the governor would have to act upon it.
Have to act on that.
I'm not sure.
Representative Button, the governor can unilaterally grant a 30-day reprieve, so a stay of the execution.
Okay.
On the clemency, the Board of Pardons and Paroles, it's my understanding, has until 48 hours before the execution date.
Okay.
And to make the recommendation. They can do it earlier, but that's their deadline, I believe. And the governor would, of course, have to decide within the 48 hours.
48 hours.
2 days.
Okay.
Yes.
Thank you. Thank you, Chairman. So then the Board of Pardons or whatever the official name is, how long usually take them, like if they get a request, how long usually take them to get this procedure, this process done?
I think in terms of the clemency process,
Yes.
Because of their rules coming really late in the game, I think Chairman Leach hit it. I think it can be done earlier, but certainly it's timely if they do it within that period of time. And certainly there is added pressure all around when you're within 48 hours of an execution date. And certainly a governor in that kind of situation would have to respond, within almost immediately in order to avoid the execution kind of thing. Now, in terms of their general demeanor, I would say on the average parole case, they would usually make a decision within a week or 10 days for the person. If they present something, I've seen it take several months on more serious cases kind of thing. But this is a unique situation because you have different rules in terms of the death penalty.
But then allow me to?
Absolutely.
Okay.
Yes, floor is yours.
Just based on, it goes back to Representative Cook earlier mentioned about the sample size. I know we're not supposed to take little sample size, especially since I'm a CPA. I know the importance of it. Yeah, okay. But do you know what's the average estimated percentage of the cases really ended with clemency, free to go like that, and versus the other side get rejected in Texas? Maybe you don't have to give me the last 100 years, whatever. Just give me some kind of, so I have some reference.
My memory is it's happened once. In my lifetime,
yes.
which is getting older by the day kind of thing. But my understanding is, and Shannon might correct me if I'm wrong on this, but I remember Governor Perry did commute an individual.
There have been 3 since 2007.
3.
Governor.
3.
Okay.
3.
Not very many. The one I was quasi interested in was Mr. Foster. And there may, like I said, there's been 3. If I'll take Chairman Leach's approach on that kind of thing, but it is not a very common thing, and that was especially true back in is when Shannon Edwards said, this was a regular point. I remember one year there were 50 some odd executions said in 1 year, and so that number has dwindled considerably. So the number of times you'll see this procedure has dwindled and there's a number of reasons why that might have happened, but there's just not as many opportunities as there used to be.
So now you really make me feel even more worried about the whole situation. Of course, I'm not talking about Apple, versus Apple, since I'm not a lawyer. But earlier, I'm getting this impression, might not be a correct impression. Please, correct me. Just be honest. That the DA, sounds kind of like give me the impression is it's gonna work out. Don't worry too much. That was maybe I'm just a little bit too compassionate, but that was the case. But it's not talking about exactly the same procedure, okay? But I am a little bit worried about that. Time is running out. Could you help me out and say, oh, don't worry, Representative Button, you worry, you just a worry bird like
well,
that.
no, what I've seen on these kind of cases is it sort of splits off. Your clemency is sort of going one way in terms of you're trying to move for clemency or at least try to get a stay of some for 30 days or whatever. What I think the district attorney was referring to or the more court process.
I know that it's different.
It is a different realm, and I think what I heard him say is I think he believes for one or more reasons that it will probably be postponed. I think that depends on which chair you're sitting in, whether you want to go with that. If I was on the defense side and we're 2 weeks out, I'm not sure I'd feel quite as comfortable as if I would from the prosecution side on this particular one. But I think he's given us his years of experience and what he expects based on all the facts that have come to his office. That's my 2 cents.
I want everybody knows that Chairman Leach, you have been just extremely compassionate and passionate about this case. See, I'm getting the text message from Chairman Leach at like 10:05 p.m. Okay, and then I usually wake up like 5:30. Then I woke up 5:30. I saw he already texted me something else related. So yeah, so not just me and everybody. Okay, so you can tell we we are very, very much serious about this whole issue. Absolutely.
It's worthwhile discussion.
You get those lay light? Oh, yeah, okay, yeah. Okay. So thank you, Chairman. I'm embarrassed.
No, it's not just me. There's a lot of folks who are passionate.
I think everybody needs to know this is how we feel. And we are elected by Texans to do our job. And this is what supposed to do. And thank you for you coming to share your expertise with us. Thank you.
You're more than welcome.
Thank you for those gracious comments. Alan, thank you. Members, any other questions? Representative Morales or Dean Thompson?
I'm fine, Mr. Chairman.
Okay. Okay, Alan, thank you. Thanks for being here today. Okay, members, any closing comments before we wrap up and adjourn? Representative Powers.
Thank you, Chairman Leach and Vice Chair Moody. To the committee, I just want to say thank you, Chairman Leach, for calling us together for such a time as this. Certainly important and imperative that we have this type of conversation. Thank you.
Yeah, thank you, Vice Chairman. Thank you as well. Thanks to all of you, and to you folks in the audience, to the Lucio family. Thank you for being here today. Our continued prayers are with you and Melissa, and we're going to continue to do everything we can. We're not going to rest after this hearing. Members, to you, I want to thank Speaker Phelan again. I know he's been watching today, and I'm hopeful other statewide officials have been as well. I'm confident that they have. And members, I just think that this has been really, really good and helpful. I'm hopeful that the right reforms will be even past this case. We've clearly got work to do as the legislature. And as we get ready for next session, that's our job. So thank you to the people of Texas. Continue to pray for liberty and for justice to be done, and confident that it will be. And with that, members, the chair moves. That concludes today's agenda. If there's no further business for the committee to address, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned, subject to the call of the chair.
Well,
damn, that was tough.
what did you think? I'm getting messages. See, I told you he's not going to do anything. He's not going to do anything. But I don't know. I think the spotlight is on him now.
I think that he now knows that he's the fish in the glass bowl, because this is going to go so viral. It's going to let the state of Texas citizens know what a chicken shit little bastard he is.
Yeah, a lot of what he said when he said, didn't he say something like, "Why should I? Why would I do that? Why should I do that?" And it's like,
he double talked.
Yeah, sure did.
And if he wanted to see the evidence, why didn't he talk to me whenever I went and tried to interview him? Pot liquor, he's a liar.
Yeah, I think there's a lot, even though he said what he did say, that if the court did not act to, what did he say, to stop the execution, one of the appellate courts?
Yes.
He said that he would. That's what he said.
He also made the comment that, about the jurors and their statements. My understanding is that those jurors wrote their own statements, period.
Yeah.
And the other thing that I that kind of raised my eyebrow was when Shannon was on there with the Texas criminal prosecutors, whatever. I could see if it was only one juror who came forward and said, "Hey, I think I might have got it wrong." But when you got 5 and one of them is your jury foreman, that's big. So, an 11-1 vote would have not gotten her the death penalty, but a 5-7 vote, that'd have been deadlocked.
Yep.
And the other thing that he really kind of, I'm like, he said that he didn't know the credentials of these people or whatever. When these experts turn in their reports or studies or research or whatever, their vitae is also attached to that. So he knows what their credentials are.
Yeah, it just sounds like a lot of obviously he's covering his ass. He's trying, and he's totally not sympathetic to this case at all.
Oh, none. And for him to say, God bless you, and knowing what kind of attitude, oh my God, Pontius Pilate.
Yep. So, and I don't know, and he's intent on letting this thing ride as,
what did I tell you at the very beginning? That it could get down to minutes, it could get down to past the time, but it's not. I don't see it happening, not with his attitude, unless these legislatures come in and put some cajitas on him. Because right now, he's just pumping sunshine up everybody's rump to make them look like a glow-in-the-dark bunny.
Yeah. I was hoping to get a feeling from him that was different, but he delivered. I think he delivered what he truly is, and I don't think anybody got a good feeling about anything he had to say, even though he said, "Oh, well, if they don't do that, then I'll do it." But
I got a text from Margaret Schmucker while she was sitting there, and she said, "This is extremely painful."
Yeah.
And knowing Margaret, she probably wanted to get up and shout in his face.
Yeah, when they asked her, "Would you withdraw it?" and he said, "Why should I?"
Exactly.
Why should I?
And people, that's what y'all elected down there in Cameron County. That's the whole kick to the butt.
Yep. That's why research is necessary. Know who you're voting in.
Exactly. We just have that going on right here where I'm at. We have a lady that's running for mayor, and I just had some kind of bad vibes, right? So I did a data background search. I had 2 clients come in and pay me some money. I did a data background search. Come to find out she's got a criminal background that she didn't let anybody know. So she's got 20 different aliases on her data thing, and she's got 41 different addresses.
Holy crap.
So that's going in the paper here tomorrow, and she's walking around town trying to solicit votes saying, oh, it was just a bad mistake, that has to be wrong. No, that's what you do. You research these people that you vote for.
Yep.
I just
what do you think is going to happen? Do you think he'll act on this now because he was put on the spot, or did this just piss him off?
No, he's hard-headed, and all it's going to do is he's going to dig his feet in deeper. That's my gut feeling.
Yeah. I think all this has now irritated him to go, they're not going to tell me what to do. And he's going to let it go till 11:59 p.m.
Well, at least 5:59.
Oh, is it 6 o'clock? All right.
Yeah.
5:59 p.m.
It's just.
Well,
and
I thought Margaret was gonna get up and say something. She didn't.
No, she did hers in a written.
Okay.
By doing this committee you only speak when you're invited to speak, and but she did hers through a written response. But I just it's very hard for me to say that there's justice here when you have Gilman and his wife and Villalobos.
Yeah, that was
the Three Musketeers.
I mean, we already know from watching the film and talking about this for weeks and weeks and weeks, but for this to come out there, that was not a good look for him. And he didn't do he didn't do himself any favors either. He didn't make himself look good at all. I don't know if he cares about that or not, but he did not make himself look favorable at all.
He was so arrogant.
Yep.
I mean, I'm like, really? Just so very, very arrogant. And, these are people that can make or break that man.
Yeah.
They can put a whole lot of heat on that man in a lot of different ways. And, I'm like, I'd be saying nice things. I'd be listening instead. My grandmother used to say, you got two ears to listen better with and one mouth to open.
Yeah. Yep. So now, again, it's a wait and see kind of a thing. I'm going to reach out to John, see if he'll be available to talk a little bit later. I imagine he'll still be there for a little while at the Capitol. And
yeah,
I'm sure
Margaret's supposed to visit with him for a few minutes as well. So I'm not sure how long that will take, but
yeah, I thought it was funny. John was streaming from his seat there.
I loved it. From the very beginning, whenever Margaret and I started on this case, we agreed we're going the 11th hour. We're going the 9 yards, and we have not abandoned Melissa at all.
Yep. I saw you. You got very emotional early when I think it was was it Alvarez? Is that his last name? The juror? Galvan. Yeah. When that juror came up to give his statement via, I believe it was his daughter, I think. And I know you got emotional there. And then even with what Mr. Leach was saying, and it's just yeah, you wish there was something more that can be done, but it's just you have to let some of the processes work. It's hard to just sit here and wait.
Yeah.
Yeah.
We
did put the phone numbers up there to the DA's office, the Cameron County DA's office.
Hey, blow it up. I mean, wait. I don't mean that like physically blow it up. I mean, make lots of calls. Let me correct that.
Yeah.
I don't want some cop come knocking on my door.
Oh, Lynn Marie said we should. Yeah. No, make the calls and let him know how you feel. Let him know how you feel. It can't hurt at all whatsoever.
You've got him and you've got the Board of Pardons and Paroles. I think you put the thing up. I put it in the comments.
Yep.
Email is there. Phone numbers are there.
Oh yeah, that email, that last one he read to the Pardon and Paroles people.
Yes.
Was that BPP_PIO?
Yeah, I took that directly off their website.
Yep. That's up there, and links are up on the site. Do what you can, make the calls. If you got to write, snail mail, that's fine too. Phone calls will be great, and again, share. This stuff needs to get out, and I think I'm glad that the DA was there and actually participated. I mean, I don't know what would have happened if he didn't. I don't know if he was obligated to be there or not.
I think there would have been a warrant issued. Damn, I'd have made a trip to Brownsville to see that one.
Yeah.
You know what I found really peculiar is that multiple times he made the comment that he had not looked at anything yet. That he had not looked at the statements from these experts.
Oh, yeah.
Alleged experts, as he said.
Right. It was obvious that he didn't. And yeah, this is just, he's probably too arrogant that he doesn't care about any of this, but any normal person would go, dang, you know what? Yeah, let's refocus a little bit and see what we can do here.
Whenever other people are trying to show you, okay, when I teach sewing, I'm going to show you my way. But you know what? There are thousands of different ways to do the same thing that I do. And I listen to these other people because I want to be educated.
Yep.
One person cannot know it all. But Manny, I want to thank you for keeping on top of this and for educating people. And we're going to ride it all the way through.
Yep, absolutely are. Everyone, thanks for hanging out. Thanks for, I don't know, it's going on 3 hours pretty soon, but it was very, very captivating. That discussion with the DA, Mr. Science, and the committee members was very, it got heated here and there. And he definitely was put on the spot on a couple things, and he tried not to bend. And after a little while, he did bend a little bit. Well, if they don't do that, then I'll do something about it. Instead of just doing something about it, and then he claims that he didn't know whether or not he had the authority. Remember that part?
33.141. That's a Texas Penal Code. That's part of that's Lawyer School 101, 33.141.
Yeah, they asked him,
And
do you
I'm
have
not a
the
lawyer.
authority? Do you have the authority to pull the plug? And what do they call that? Recall the death penalty warrant?
Yeah,
And he said, no, recant. Yeah, he's like, he goes, I don't think I have that authority. And then,
How many judges y'all got down yonder?
Oh,
How many district judges you got?
yeah, too many.
Well, then you know what? There's at least one that could sign that.
Yeah, and he claims that there's nobody. They've got nobody. Nobody's assigned yet. Nobody will look at it. Which is,
Go get you some rest.
Yeah. Everybody, I may be back later. I don't think I'm done talking about this yet. I'll let you know if I'll come back. Lynn, Marie, thank you so much for commenting and viewing this with me. Everybody loves to see you.
Y'all have a good one.
Thanks for watching, and I'll come back later on.